Okay, thank you, Deputy. All right, please be seated. The state may proceed with rebuttal.
Thank you, Your Honor. Members of the jury, Daunte Wright was shot to death by a gun in the hand of a highly trained police officer veteran. That is what this case is about. No matter how hard the defense tries to recharacterize the case, distract you from the law and the actual evidence of the defendant's conduct, that's what this case is about. This case is about a 26-year veteran police officer who trained every year on the use of her gun. She had to qualify every year on the use of her gun to keep her license, who trained every year since 2002 on the use and handling of a taser, training that included the concept of weapons confusion and wearing it on the other side from your handgun, training that included proficiency. You heard Sergeant Peterson explain that means being able to draw the taser and handle it. Who had years and years of wearing and drawing that taser from her left side. Who during this incident had two officers with her who were subduing Mr. Wright, who, whether it was a good idea or not, decided to use her taser, but who instead disregarded those years of training and practice, pulled her gun with her right hand instead of her taser with her left hand, thought enough to give the verbal warnings, but not enough to realize, to be aware, she was pulling her gun. My review of the video, you rely on your own review of the video, but she has her gun in her hand, pulled out of the taser for some 7 seconds. Somewhere between 5 and 6 of those seconds, she has it held out in front of her. And then she shot Mr. Wright in the chest from a foot or two away. There's no mistake defense. You will not see an instruction on the defense of mistake. The judge will not give you an instruction that says a person is not guilty if they commit a mistake. That's not the law, no matter how often the defense says mistake. How can you recklessly handle a firearm? That's exactly the point. Right? She pulled her handgun instead of her taser. And that was her apparent intention, was to pull the taser. That's recklessly handling a firearm. That's how. These alleged crimes are based on recklessness, the reckless handling of a firearm by a highly trained professional who was trained to know about the risk of confusing a taser for a gun, or the other way around, and who pulled her gun and shot Daunte Wright. These alleged crimes are based on a trained police officer's conduct in deciding to use a weapon, being aware of the risks of drawing the wrong weapon, and then disregarding the risks and shooting Daunte Wright to death. Being aware of the risk. That's what the law is in this case. Now, you have heard testimony about whether Potter's decision to use her taser was reasonable or appropriate. The judge has given you a definition of reasonable force, reasonable use of non-deadly force, in case you want to consider that testimony and the legal requirements about her decision to use a taser. Mr. Gray, He has criticized us for putting in evidence about the crash and the Lundgrens. Here in this trial, that testimony was offered to you to show exactly what officers are trained to think about: collateral danger. Right? Shooting somebody who's in a position to operate a vehicle, officers have to think about that. And that's exactly what happened here. Except Officer Potter did it with her gun by shooting Daunte Wright in the chest. That's why that evidence was offered. When you consider the defense argument, incidentally here for a moment, think about criticizing us for putting in evidence that has relevance to the issues. But the defense put in character evidence about Miss Potter and concluded with that, arguing to you that she's a good person. What's the relevance of that testimony? She may be. What's the relevance to the issues in this case? Mentioning that Mr. Gannon was a Marine, and I think...
Object to that. Obviously, character evidence is relevant.
The objection is overruled.
Mr. Gannon, who served as a Marine, and I thank him for his service, I'm sure we all do, and it's impressive. He pointed it out to you today. What's the relevance of that testimony? Anyway, ultimately, you really may not have to decide whether her decision to try to use a taser was reasonable, because that is not a defense to the charges. It's right in the judge's instructions. It's not a defense because the conduct at issue in this case is firing the gun that killed Daunte Wright. Whether her decision to use a taser was reasonable, appropriate, wise, may be considered by you to determine, based on the totality of circumstances, her entire course of conduct. But it is not a defense to her use of deadly force, what she actually used. I'm going to address the issues raised in the defense argument in slightly different order. I'm going to first talk about the argument about using deadly force. Counsel says you can acquit her because she could use deadly force. This is primarily based on a contention that Sergeant Johnson was in a position to fear. Well, what's required is that there be evidence of an apparent belief of death or great bodily harm. This claim is simply wrong based on all the evidence in the case. Her conduct, the facts that would have been known to her, and her testimony. This defense argument about the use of deadly force, when she herself has said at the scene she did not mean to use deadly force, is a justification, an after-the-fact justification to avoid consequences she acknowledged immediately out there on the street. The judge has told you to use your common sense in deciding the issues and the believability of witnesses. Common sense tells us all that often when people try to make up justifications later for things they have done, the justifications fall apart because they just can't line up with the facts. The facts exist. You have seen them. And if they can't be hidden or obscured, they render the justification incredible. Here's a simple illustration, I think, of what I mean by that. Ms. Potter wants you to believe that Mr. Wright was not in a position to operate the vehicle so as to justify her use of the taser. Because if he's not in a position to operate the vehicle, it's okay to taser him. I brought in Mr. Imes to tell you that. And they had people say, well, he wasn't in a position to operate the vehicle. But yet, they also, Ms. Potter wants you to believe that he was in a position to operate the vehicle to justify deadly force to protect Sergeant Johnson and Officer Lucky. Those things are inconsistent. And that's the problem with trying to create justifications later. Now, which is it? The evidence will tell you which it is. Ms. Potter did not believe that the use of deadly force was necessary to protect anybody. She just wanted to keep Daunte Wright from fleeing a traffic stop her probationer had initiated. Mr. Gray is right. The state has to prove that Ms. Potter's use of deadly force was not authorized. He's right, that's our burden. You'll see that in the instruction, plain as day. That instruction also says that deadly force is authorized only if a reasonable officer, knowing what the officer knew at the time of using force, would have believed deadly force was necessary to prevent great bodily harm or death. Potter's assertion now that she could have used deadly force to protect the officers is simply not supported by the evidence. First, consider the testimony from Lucky, Johnson, even if you will, Flesland, Gannon. Those statements, that testimony, simply lacks credibility. Look at the videos. You believe your eyes. Look at the videos. Watch them in real time. That's fine. I encourage you to do that. We slowed them down so you could understand what's happening there. But sure, watch them in your own time. I agree with that. But you can believe what you see in those videos. What you see in those videos is Daunte Wright never assaulted these officers. The characterization of fighting and struggling is not supported by the evidence. Those are just terms used, not supported by the evidence. He was trying to flee, no doubt about it. But he was not struggling or fighting with these officers. He simply pulled away, tried to operate the car. He never even threatened the officers. Nobody has disputed those facts. You saw in the video during the testimony of Sergeant Johnson that he had control of the car and Daunte Wright. He reached in, tall man, standing firmly on the ground next to the car, leaned against Elena Albrecht Payton, who obviously didn't put up any resistance to an officer of his size, didn't put up any resistance, just leaned against her, put his right hand on the shift knob, and you can watch that video and see Daunte Wright's hands reaching for the shift knob, but he can't move it because Sergeant Johnson has control of that shift knob, and he's reaching up to shut the car off. During that time, Sergeant Johnson says something to Elena Albrecht Payton, something like, "Just stay back." Listen to the calmness in his voice. You know, is that the voice of an officer with a look of terror on his face that a 26-year police veteran had never seen before? Then, Sergeant Johnson stays in the vehicle, not in the vehicle, leaning in, and he takes his hand off the shift knob and is able to grab Daunte Wright's right arm with both of his hands and pulls Mr. Wright's right arm over in front of Elena Albrecht Payton in the passenger seat. He's not concerned about being dragged. He's subduing Daunte Wright. And he's doing that because he assumes Lucky on the other side is going to grab the other arm and they're going to be able to handcuff him. That's what his testimony was. Potter's trying to make much of Johnson's testimony. Remember that these were leading questions put to fellow officers. I'm not saying officers lie. The judge will instruct you when considering the believability and weight to give testimony. Think of the relationship between the parties. These were leading questions put to Officer Johnson. His question was, what would have happened with you halfway in the car? That's my recollection of the question. Rely on your own. Sergeant Johnson wasn't halfway into the car. At the time of the shot, he was all the way over to the passenger side, securing Mr. Wright's right arm. He had control over Daunte Wright. The only time Sergeant Johnson became concerned is when Potter used her taser, said she was going to use her taser. Recall that Officer Lucky testified, and with rapid succession of leading questions, they asked him, well, if you had been in the car, you could have been dragged and hurt. He said, yeah. Well, remember again, that's a hypothetical question. And what the real evidence is that Officer Lucky was standing outside the car. At most, he reached an arm into the car. He tried to grab a hold of Mr. Wright. At one point, he tried to grab the steering wheel or the steering column. He's standing outside of the car, his feet on the ground. He's no more in the car than Potter was. Recall that counsel asked him, as far as you knew, Johnson was in the car. Lucky dutifully agreed with that.
Judge, I object to this. I didn't go into this
The
testimony.
objection is overruled.
For the record, Your Honor.
No.
But during that time, Potter is on the other side of the car from Sergeant Johnson, sometimes behind Officer Lucky. Recall Officer Potter saying she's 5'3". Look at the video. Yeah, her body camera's down here, and her eyes are up here, but she's only as tall as the car. So counsel pointed out, we're talking about the body cam, we're showing you the body cam. Yeah, but her eyes aren't going to be any better perspective of Sergeant Johnson. Just look at the video, see where she lines up with that car. And you heard Dr. Miller talk about hyperfocus. Well, if she had this kind of tunnel vision hyperfocus during this chaotic scene, how did she see Sergeant Johnson's face with this look of terror? The bottom line, factually, is that the opinions of Lucky, Johnson, for that matter, Fleslin, Peterson, Gannon, on which she bases her factual claims, were offered on leading hypotheticals, not the actual facts of the case. This is particularly true of Fleslin, Peterson, Gannon. Fleslin and Peterson only watched brief snippets of the video. Right? They didn't review all of the evidence in the case. Seth Stoughton did. They didn't interview witnesses. They admitted to you all. They were just offering opinions on hypotheticals from Miss Potter. Mr. Gannon indicated that he watched Miss Potter's body-worn camera that night and immediately concluded this was an accident. Right or wrong, he believes he was fired for it. But then anyways, at the request of the defense, he then went and watched a squad camera. And that was all. The squad camera's perspective is behind the Buick, the white car, and a little off to the driver's side. It's not a good perspective of Sergeant Johnson's position. The fact is, Gannon didn't even watch Sergeant Johnson's body-worn camera. You have. The facts simply don't support these assertions, but more importantly, these assertions don't even address the proper legal argument you have heard, and you will read in the judge's instructions, that the standard is what a reasonable officer in Officer Potter's position would have known. Not one of those witnesses tried to explain that to you. Not one of them have offered an opinion that it would have been apparent to Officer Potter. Second, I want you to consider the sources of these assertions. Again, the judge has told you in her instructions that when you consider the believability and weight to give to witnesses, consider the interest in the outcome of the case, the witness's interest in the outcome of the case, and the reasonableness in light of other evidence, as well as the relationship of the witness to the parties. These officers were part of her police family. She called it that herself. They worked with her for many years. They relied on her. She relied on them. They were backup for her and vice versa. They liked the things she did. The honor guard. I think we can all like that, right? I mean, that's good stuff. That she did, no doubt about it. The domestic abuse response team, that's good stuff, right? And they all spoke highly of her for it. On the other hand, Professor Seth Stoughton is not a part of Officer Potter's police family. He did work as a police officer. He worked as a licensed investigator. Then he went to law school. And since then, he has become an expert in policing. He teaches at a law school. He researches issues related to policing. He publishes extensively. And he speaks to all groups about these issues, not just police groups. Potter kept referring to him as the $95,000 guy or the $93,000 guy. That's not what he charged in this case, right? He testified on the stand. He's so far charged something like $9,000. Yeah, he's an expert witness. He gets paid. He can get paid $95,000. Why use that term? Just going to distract you from the reality. He took the stand anyway, Seth Stoughton, and explained in great detail for you in his own words, not mine, the evidence he believes shows that Potter did not have a reasonable belief that some officer was in danger of death or great bodily harm. He explained the bases for his opinions properly in terms of what a reasonable officer would have known at the scene, the proper legal standard, and he explained it, and he was subject to cross-examination about it. Mr. Imes, on the other hand, who has spent his entire career completely immersed in police organizations, dedicated his life to it, told you that, can't remember if he said 110% or more than that, simply offered a short opinion. Not accepting a fee for his services because that's how important it is. He still was not sure if he had reviewed all of the materials when he wrote his report. He wrote a report that was just over 2 pages in length, and he did not even consider Potter's use of deadly force until after the trial started and the defense brought it up to him through Sergeant Johnson's testimony. Yes, he drove up here. That's how much he cares. But he didn't even know if he had reviewed all the material. Didn't even think about deadly force until it was brought up later. Tim Gannon.
The objection is overruled.
I think I already talked a little bit about Mr. Gannon. I would point out here, he too made no attempt to offer a basis for his opinion, certainly not at length. Didn't even watch Sergeant Johnson's body-worn camera video. An interesting thing, also, incidentally, that I want to point out, Commander Grunig and then Chief Gannon authorized the BCA to come in and investigate the case. And why is that? To avoid any appearance of bias.
Judge,
Right?
I never mentioned the BCA. Some proper
The
rebuttal.
objection is overruled.
And so they recognize in bringing the BCA in to investigate the potential for bias of fellow officers. You should feel free to consider then that recognition when they nonetheless come in here and testify. But in the end, despite all of that, you can rely on the most important evidence of all, Ms. Potter's own actions and words. Her actions and words before, during, and after she shot Daunte Wright in the chest. There's an old expression that actions speak louder than words. We've all heard that. Here, I think they both speak at the same volume. For her actions and words speak very loudly that she did not believe deadly force was necessary. She clearly said taser over and over. I'll tase you. I'll tase you. Taser, taser, taser. It's consistent with training. Training to provide notice to the subject and other officers. She only pulled the trigger once. You heard testimony that that's what you do with a taser, not a handgun. After she immediately expressed surprise that she had shot him. She immediately said she had pulled the wrong gun. She punctuated that admission with profanity. Pulled the wrong fucking gun. She emphasized. She immediately expressed shock that she had done something so very wrong. Consider the real volume, if you will, of her reaction. She is distraught. She is beside herself. She questions how she could have done this. She collapses to the ground and admits how wrong her conduct was. I'm going to prison and I killed a boy. Is that the reaction of somebody who thought deadly force was really necessary? Also important is what she did not say. She never said, I had to shoot him, or somebody could have gotten hurt, like her fellow officers, her police family. She didn't even take Sergeant Johnson's offer to say that when Sergeant Johnson said he was trying to drive away with me in the car, which isn't even true. But he offered that to her and she didn't even bite on it. She was so caught up in the recognition of the wrongfulness of her own conduct. Finally, consider her own words to you here in court under oath. She admitted to you here that she did not mean to shoot him with a gun. When she was asked about it, she knew deadly force was not necessary. If she didn't believe deadly force was not necessary, how could a reasonable officer in that position believe it? Incidentally, so let me summarize. There simply is no evidence upon which to believe a reasonable officer in Officer Potter's position would have believed that deadly force was necessary at that moment in time. One of the things I want to make sure I point out was mentioned that you're going to have the Glock and the taser back there with you. They will be rendered safe. But keep in mind that the Glock...
This is not rebuttal.
The objection is overruled.
Remember that the Glock has been unloaded, right? That's how one way we're rendering it safe is to take the ammunition, keep that separate. So if you're going to consider the weight, just keep that in mind, please. But you can look at them and see the difference. And we wanted to make sure that you could put hands on it, as Officer Potter had done with her firearm and her taser for many years. All right, I want to talk, I think, somewhat quickly about this argument on causation. That Potter believes Daunte Wright caused his own death is somewhat stunning to me. And let's talk about that for a minute. You know, we have this concept we like to call branding, rebranding, using words to try and change people's perspectives of things. I want you always to think about that in this case as you're evaluating the evidence, using words like the car taking off like a jet, which of course was at the time being operated by somebody Miss Potter had just shot in the chest, blew up his heart, blood's pumping into his chest. Dr. Jackson, I think, said we would call that survivability in seconds to minutes, I think is what he said. But yet we're taking off like a jet. Elena Albrecht-Payton told you he's just sort of like gurgling, gasping by the time they crash. Unfortunately, Daunte Wright's already dead at that point. Taking off like a jet. This notion of fighting or struggling with Daunte Wright in the car, I talked about that already. The fact that he was high on marijuana or stoned. Elena Albrecht-Payton told you he wasn't acting like he was under the influence of the marijuana. There's no evidence. You watch the videos. These are used, these terms, to lead fellow officers and maybe you into believing things that aren't really true, to change perceptions of what happened, to rebrand a case as the case about Daunte Wright. And this contention that he caused his own death is factually wrong and legally wrong. It's factually wrong because, very simply, as you saw, Kim Potter shot a bullet into his chest, passed through his chest, blew open the front of his heart, and came right to lodged in his skin. You don't have to, but you can watch the video of the attempts at doing life-saving measures on him, and they put on a dressing that pushes the bullet back in. That's what caused his heart to stop beating and die. To an absurd extent, Potter now attempts to argue that he caused his own death. And I want you to consider, if we accept that argument, that he caused his own death, we have to accept that anytime a person does not meticulously follow the commands of a police officer, they can be shot to death. And there would be no consequences.
The objection is overruled.
And there would be no consequences to that officer. That's absurd. It's also contrary to common sense and the law. Every officer that was asked admitted to you that in making arrest, officers have to use reasonable force. I mean, that's why we're here. She didn't use reasonable force. She shot a man. I would have preferred had Daunte Wright followed the commands and not tried to flee, sure. Does that absolve her from liability? Does that allow her to shoot him to death? It does not. Officers still have to use reasonable force in apprehending a person. Now, Mr. Gray talked to you about superseding clause. He read to you the definition. It's plainly in the instruction the court read to you and will give copies of to you. He read it accurately. He's just completely wrong about how it applies. A superseding clause, if you think about it, it makes sense. A superseding cause is a cause that comes after the defendant's acts, that alters the natural sequence of events, and is the sole cause of a result. Ms. Potter's acts came after. For Daunte Wright, for his conduct to be the superseding cause, his conduct has to come after Potter's acts. It's right there in the definition that he read to you. Well, how is it that Officer Potter threatened to use her taser if Daunte Wright hasn't even started fleeing it? This is a clear diversion, an attempt to blame Daunte Wright for his own death. It's not a superseding cause because the conduct that they claim as a superseding cause started before. It put into motion these events during which Officer Potter decided she would use force and pulled out her gun instead of her taser and shot him. It's not a superseding cause. You can read the instruction, it's plain as day in there. Finally, and I do mean this, I need to address what I contend is a mischaracterization of the law underlying the charges here. This notion of mistake or gun in hand. Dr. Miller got paid a $30,000 flat fee to come in here and tell you what? That people make mistakes. Good for him, I guess. It's not really relevant to the case, right? There's no defensive mistake. It's like a friend of mine says, it's like blaming gravity for falling down a hole, right?